Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Indianapolis on September 28th through the 29th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and in this episode, I am pleased to be joined by David Bitkower, a former Principal Deputy Assistant Attorney General for the Criminal Division of the Department of Justice, the second highest ranking position in the division. Bitkower is currently a partner at Jenner & Block. Thanks for joining me today, David.
Thanks very much, Mike. Thanks for having me.
Now, in a recent article you authored titled DOJ Must Be Aware of Unintended Consequences as Multilateral Settlements in the FCPA Context Arise, you note that the DOJ has been talking for a while about offsetting penalties for companies prosecuted in multiple jurisdictions. Can you walk us through what you see as new and some of the more recent settlements in this area?
I can. Thank you, Mike. And I first want to note that I wrote the article with a partner of mine here at Jenner & Block named Nicholas Barnaby, as well as one of our associates, Marguerite Muller, and it was very much a joint effort. And so I'm grateful for their assistance in helping to prepare it. So the point of our article was based to a degree on my experience at the department before I left in January. And at the time, both I, but in particular the other members of the leadership of the Criminal Division, would frequently speak to the public as a way of participating in the discussions and debates around the FCPA and other corporate enforcement issues, and also to communicate enforcement priorities and likely positions to the public. These wouldn't be necessarily binding in a legal sense, but they would help indicate the department's thinking so that defense counsel would know what arguments would be likely to be effective in settlement negotiations, and they could also communicate that to their clients to understand how the department would look at certain conduct. And often what's helpful to do when a new team comes in to the government is to watch for differences, whether profound or subtle, in the rhetoric between the former leaders and the new leaders, or the same administration or a different administration. And so one of the areas that, in particular, Leslie Caldwell, who was the prior Assistant Attorney General for the Criminal Division, used to speak about when she spoke in public on corporate enforcement issues, was the need for fairness on the part of the department when it negotiated multi-jurisdictional resolutions. That is, when the department chose to prosecute or resolve with the corporation for particular conduct, and that conduct was also the subject of an enforcement action or an investigation by a foreign jurisdiction. And more, Mike, as you know very well, of course, this is becoming the new normal, where foreign corporations are subject to investigation or prosecution in 2, sometimes 3, sometimes more jurisdictions at the same time. And each of these jurisdictions is going to want to impose some kind of penalty at the end of the day for the same or overlapping conduct. So Leslie used to talk quite frequently, and I talked about it as well, as did Andrew Weissman and other members of the fraud leadership, about the need to be fair in these situations. So, for example, one case that that Leslie talked about a lot was the Deutsche Bank resolution in the LIBOR case. And she noted that in that case, the way the department would work would be to negotiate to determine the appropriate overall penalty under American law, and then to make sure to give an offset for penalties paid for the same conduct to another jurisdiction. So that way the defendant or the subject of the investigation would only effectively pay once rather than double payment. And the way we talked about that was really in terms of fairness. That is to say, it was not a legal obligation that the department take those other penalties into account, but it was really an attempt to do the right thing and make sure that companies weren't penalized twice for the same exact conduct. So after I left the department, I obviously continued to maintain an interest and to watch closely the statements coming out of the Criminal Division and out of the fraud section. And I noticed a couple of changes to the way the department talked about that multi-jurisdictional resolution issue. And a couple of new concepts crept into some of the language. So, for instance, the new acting assistant attorney general, who is acting in Leslie Caldwell's stead until a confirmed appointee is confirmed by the Senate, and he said that it was important to offset penalties for companies that accept responsibility for their conduct. And that was a new element. As I said before, when we had talked about it in prior speeches, there wasn't a requirement that the company accept responsibility. It was, again, a fairness value. Now, in reality, as you know, of course, almost every corporate resolution is going to be resolved with either a DPA or an NPA or a guilty plea, in which case there is acceptance of responsibility. So although that was a new concept, it didn't seem like one that would have a major impact in the actual day-to-day negotiation of these resolutions. But then another official gave a speech shortly thereafter, which expressly said that the willingness to offset penalties would be premised on the idea that the company had chosen to cooperate with the investigation, and the company had not engaged in forum shopping. And this was much more explicit of a condition, and it struck me as much, potentially at least, much more important. When concepts like that get into speeches by leadership of department components like that, it tends not to be an accident. It tends to be something that's been thought about and discussed, both with the prosecutors who do the work, as well as at the leadership level, because it's understood that it will communicate an important concept to practitioners. And so this struck me as something that the department had really thought about and wanted to communicate. And also something that could be very important. And if you look at some of the recent corporate resolutions involving multiple sovereigns, this idea of a fairness offset takes on increasingly important scope. So, for example, there was the case involving VimpelCom a couple of years ago, where the American government settled FCPA allegations against the company, as did the Dutch authorities. And in that case, the American DOJ offset over $200 million of the ultimate penalty because of penalties imposed by the Dutch. So that was a case where this concept led to a $200 million difference in the ultimate resolution size. A second case at about the same time involving a Brazilian company, Odebrecht, was actually 10 times as important in the sense that in that case, DOJ agreed to offset $2.3 billion of the American penalty in recognition of penalties paid to the Brazilian government and the Swiss government. So if you're going to be adding contingencies and only giving offsets if those contingencies are met, then those contingencies take on an extremely high importance, particularly when the money at stake is in the hundreds of millions or even billions of dollars range. So what had been a rhetoric based on fairness now seemed to be switching to something that looked a little closer to leverage. And obviously when the department uses leverage like that, it can have very significant effects on corporate incentives, and it can have effects on the ultimate fairness of the resolutions. So that's what our article was designed to call attention to, and to make sure that practitioners in particular were aware of the potential implications if they are the subject of multiple jurisdictions investigations, and also to make sure that my colleagues in the department could see that the private sector was aware of this as well, and to make sure that the meaning of these terms was spelled out in a clear way. That is, you could read them very broadly, but there may also be ways to read them more narrowly. And for example, the department could say with more fairness, when we're talking about forum shopping, we don't mean the decision to initially report. We mean, for example, if you're going to resolve your allegations in one country, you should do that in a coordinated way, because if you expect us to offset the ultimate penalty, we want to make sure we're at the table when that discussion is happening, not that you negotiate a penalty with one company and bring it to us and expect us simply to grant a dollar-for-dollar credit. So there's broader ways you could interpret this language, and there's more narrow ways, and one of our hopes is that by noting this in our article, we'll give the department the opportunity to be more precise in its articulation, and also make sure that practitioners in the field and companies subject to this kind of regulation are aware of these implications.
Yeah, I'd like to broaden the issue out a little bit further. Your article talked about offsetting penalties and the fairness issue there, which I think most reasonable minds would agree with. But more broadly, I think is the important policy issue of whether the DOJ and the SEC should even bring FCPA enforcement actions against foreign companies that are domiciled or headquartered in OECD Convention countries where there is a related foreign law enforcement action. So, for instance, in 2016, obviously a record-breaking year for FCPA enforcement, approximately 40% of corporate FCPA enforcement actions were against foreign companies. And even more dramatic, approximately 65% of the settlement amounts in those enforcement actions were those involving foreign companies. Now, all the foreign companies that resolved FCPA enforcement actions in 2016 were from OECD Convention countries like the United Kingdom, Brazil, Belgium, Switzerland, and there's some other examples. So my question, and this is particularly relevant, I think, given that Article 4 of the OECD Convention says that when more than one party has jurisdiction, there's supposed to be a consultation to determine what is the most appropriate jurisdiction. So a long-winded introduction, I guess, as to the policy issue of whether the DOJ or the SEC, for that matter, should even bring FCPA enforcement actions against OECD Convention country companies when there is a related foreign law enforcement investigation.
So I think that's an important question, Mike, and I think it gets at some of the same issues that we were just talking about in terms of fairness and the risk of double punishment for the same conduct. And I also think it gets to an issue on the government side of where it makes the most sense to spend limited resources. So I think it's an important point that if the relevant interests are being fully and fairly vindicated by another sovereign, another investigative authority, then not only can it be unfair to the company to be investigated again by Americans, it also may not be the best way to spend your tax dollar. But I do think there are a couple of complicating factors there that it's important to point out. So the first factor is, most obviously, sometimes the conduct under investigation or prosecution by the foreign authority overlaps with, but is not entirely coextensive with the conduct that is the subject of the American investigation. And so that obviously depends on the jurisdictional provisions and the prioritization and the appetite and the capabilities of the foreign law enforcement agency in terms of whether they are looking at the same alleged bribery, for example, or the same corporate misconduct more generally as the Americans are. And so there may be a case where it makes sense for the Department of Justice or the SEC to focus on conduct even if the same company is being investigated for related or overlapping conduct. The second issue, though, that I think is a little more tricky and is not really susceptible to clear rules here is that it can be very hard to say up front, and I can draw upon my experience in the department for over a decade here in saying this, how a foreign law enforcement authority is intending to proceed. And this is particularly the case in matters involving corruption, where every country country, of course, has different legal structures and different capabilities and competences, and it is not always clear, even if a country has launched an investigation, and even if a country is proceeding to a prosecution, that investigation or prosecution truly vindicates the same interest that the Justice Department would want to vindicate given that conduct and given the existence of American jurisdiction. It may be at the end of the day that it does. It may be at the end of the day that the investigation or prosecution was not as full and fair as the department would have liked it to be, in which case there may be a desire to impose additional penalties for the same conduct, given that assessment. Now, I think that brings us back to the point we both started with, though, Mike, which is that's why, as a matter of fairness to the company, that a very searching inquiry be done to make sure you are avoiding exactly that kind of double penalization that we talked about in the first place. That is, assuming the foreign investigation was full and fair, assuming it did cover the same conduct, and assuming that government had a legitimate interest in assessing those penalties, then, as a matter of basic fairness, does it really make sense for the government of the United States to impose the same penalty for the same conduct, even if the company has chosen not to cooperate with the investigation and they've stood on their constitutional rights, or even if they disclosed initially to the company where they are based, as the country where they are based, as opposed to the American authorities. In those cases, I think there is still a clear fairness interest in avoiding that kind of double punishment.
Now, what you describe in terms of the U.S. not necessarily knowing what a foreign law enforcement agency may be doing, at least from my perspective, I understand that in theory, but as a practical matter, some of the more high-profile enforcement actions, including those that you mentioned earlier, there was a global resolution literally announced on the same day in coordinated press releases. So as a practical matter, is that even a significant concern given how frequently the U.S. FCPA enforcement authorities are cooperating and sharing information with their UK or Brazilian or other European counterparts?
I think it is very fair to say that in cases where there is close cooperation and coordination, and where global resolutions are potentially available, that in those cases in particular, it's fair to hold the department to the highest standards of making sure they are not engaging in double penalties and that they are coordinating with those foreign counterparts to make sure it really is a coherent approach internationally. And I think that's an important lesson for practitioners as well, is to make sure that they are conscious of that possibility while the investigation is ongoing, and avoiding situations where the different sovereigns are potentially working at cross purposes in ways that can be unhelpful to the company at the end of the day.
Well, time will tell whether what I think we both agree is probably a fair process actually plays out. I do know this: if the DOJ and the SEC would stand down in certain of these cases, a large portion of their historical enforcement activity and thus money secured through those settlements would sort of disappear, and you can imagine how many people in the FCPA and related space would raise concerns and get agitated about that. Another question I've been asking a lot of guests on my podcast in recent months as the FCPA approaches its 40th anniversary is, has the FCPA been successful in achieving its objective of reducing bribery? Which, of course, begs the question, how does one even measure success? So how would you answer that question, both from a big picture standpoint of what should success mean in this space, and whatever your definition or definitions are, has the FCPA been successful in the legislative goal, after all, which was to reduce bribery?
Well, that's a great question and a difficult one to answer. So I'll start by saying that if I put back on my hat from when I was in the department for so long, I think it's very important for prosecutors to be aware that criminal justice is not typically the solution to societal problems. It answers very discrete matters of crime and injustice, but typically to solve broader issues, including corruption, for example. It's one part of the puzzle, and it's not the whole thing. So I would always be careful not to measure the success of a global effort, for example, to combat corruption, based on statistics of number of prosecutions launched and dollars recouped for the Treasury and the like.
Yeah, and I completely agree with that. I've sometimes referred to that as hard enforcement, the actual enforcement actions brought, and I agree that while that could be one definition of success, that's probably not the best way to look at it, just like it's probably not the best way to look at whether traffic laws are successful by looking at the number of speeding tickets issued.
I think that's exactly right. And so one way to look at whether the FCPA has been successful in the larger goal of addressing the issues of corporate involvement in overseas corruption is by the attention spent by companies on compliance and on avoiding those problems in the first place. And in that sense, of course, again, there aren't going to be hard statistics on this either, but I do think it's fair to say that since the FCPA was first enacted, there has been a dramatic increase by corporations on making sure that their agents abroad and their employees abroad are cognizant of those requirements and of doing the right thing, and that is of not trying to get ahead through bribery of foreign officials. Another way I think you could look at the success of the statute is in that broader effort, which was part of an effort not just by the United States, but by the United States to have its allies, its OECD allies, and others to take efforts to increase enforcement and awareness abroad. And there again, I think it is fair to say that the goals of the legislators have been met to agree. There has been a marked increase in enforcement activity, by our foreign partners on some of these issues, and you can imagine a world certainly in which that trend continues, and there is less of a role for the United States to play in prosecuting corporate crime that takes place largely abroad. So I would push back against the suggestion that more prosecutions means a failure. I would also push back against the conception that more prosecutions means a success. That depends, of course, on not just the prevalence of crime, but also the evidence that's available and the priorities that the department takes and where else it's looking to spend its resources. But I do also think that in 2017, when you look at corporate behavior overall, particularly the behavior of corporations subject to American jurisdiction, you do see a marked difference from what you saw in the 70s.
Yeah, and as to the meaning of success and how companies are reacting to this, we now are up to, I think, 10 companies being FCPA repeat offenders, including some companies in a very short amount of time. And I completely agree that the compliance landscape really over the last 5 to 10 years has remarkably changed. But oftentimes compliance means more internal audits, which means learning of potential problematic issues, which means disclosing those issues, which means more enforcement anyway. So it's like the more compliance there is, the more enforcement activity there is, because of some of those dynamics where you would ordinarily think it would be the opposite, not what we see.
Well, there's no question that it's very important for the department to make sure that its priorities and enforcement are not structured in a way that penalize compliance. And that's certainly something that we were aware of prior to the change of administration. It's something that I'm confident that the new team, as it's being developed and when it's fully in place, will also be aware of. But it is essential that companies that take steps to do the right thing and to articulate and enforce their values on their employees and agents, and then also try to do the right thing in terms of figuring out if everybody lived up to those values and finding out the facts, are not penalized for doing so and are in fact encouraged to do so.
Well, thank you, David. Today's guest has been David Bitkower, a former Principal Deputy Assistant Attorney General in the DOJ's Criminal Division. He's now a partner at Jenner & Block, and it's always informative, both for myself and listeners, to hear perspectives of people who were recently in the government and enforcing the FCPA. So thank you for on one level, sharing insights about your recent article concerning some multi-jurisdictional issues, and for more broadly talking about the FCPA as it nears its 40th anniversary.